May it please the court, I'm here representing the defendants in this matter, the ones who remain. The primary issue in this case is the legal question of whether the individual officers are entitled to qualified immunity. In the context of this case, resolving the qualified immunity question means answering this question. In the light most favorable to the plaintiff, do the facts establish that probable cause existed to believe that Jerry Anderson murdered his wife? Or alternatively, do the facts establish at least arguable probable cause? A court ruling on the qualified immunity question first asks this question, taken in the light most favorable to the plaintiff, did the officer's conduct violate constitutional rights? Did it violate the plaintiff's constitutional rights? And on this issue, the plaintiff bears the burden of proof. The plaintiff must prove that a constitutional violation occurred. That's the first prong of the Saussure test, which, as this court knows, you can look at either prong first now. But if there's no constitutional violation, then the analysis ends, and the officer's entitled to qualified immunity. However, even if the facts in the light most favorable to plaintiff could establish a constitutional violation, the officers will nevertheless be entitled to qualified immunity if a reasonable officer could have believed that his conduct was lawful. And the cases phrase this a lot of different ways, but some ways the cases put it are officers are not liable for bad guesses in gray areas, but only for transgressing bright lines. An officer will be entitled to qualified immunity unless every reasonable officer would have understood that what this officer was doing violated the Constitution. In this case, that means that the officers are entitled to qualified immunity unless every reasonable officer would have known that probable cause did not exist in this case. In this case, the officers are entitled to qualified immunity because, one, the facts show that probable cause does exist, and two, even if probable cause doesn't exist, a reasonable officer could have believed that probable cause existed. So I will move to the probable cause analysis.
Is an officer who fabricates evidence against an actually guilty person entitled to qualified immunity?
Your Honor, when you look at the qualified immunity question, I'm going to answer that. You have to look at the specific facts of the case. You can't just state a general proposition, does it violate the Constitution to fabricate evidence? But the answer to your question is, if probable cause exists, what the case law says is, even if an officer goes in and lies to a magistrate, that does not violate the Constitution because if there's probable cause, the Fourth Amendment is not violated by the seizure. In other words, the Fourth Amendment forbids unreasonable seizures, and a seizure is not unreasonable if probable cause exists.
So what are you saying? That's like a Frank's analysis where you subtract out?
I think it comes from Frank's, but there are a lot of other cases that talk about it. The cases I'm talking about are the ones that say an unreasonable seizure is a seizure that is a seizure on less than probable cause. If probable cause exists, there cannot be an unreasonable seizure, and there can be no constitutional violation.
Well, getting back to Judge Davis's question, the officer lies in order to establish probable cause. That's not protected by any kind of immunity, is it?
In this case, the finding of the...
No, just as an abstract proposition.
As an abstract proposition, if there is no probable cause and the officer lies in order to convince somebody there's probable cause, that could be a Fourth Amendment violation. It probably would be. That's not the case we have here.
Your position is that if you lied, it's irrelevant because there's enough other stuff in this case.
Yes.
Mr. Morgan,
Yes.
let me ask you a question that's been troubling me about this case. I mean, when you look at the list of what the officers did have, there's just tremendous evidence, okay? Something happened, though, in the trial court. Where did this, from your perspective, where did this case go off the rails? Because when you look at the litany of things that the police had, it was very substantial. But the court was concerned about the lack of a written record in front of the magistrate and something else that I haven't been really able to glean from this. What can we glean from this record that supports your position that something happened that was reversible error?
You're asking me from the record at the United States District Court?
Yeah. Mm-hmm.
Well, Your Honor, the United States District Court judge, after looking at the briefs and looking at the record, I presume, uttered in open court that there were issues of fact, and he articulated basically three
No, I
issues
read
of
what
fact.
Judge Redner said, but what happened here that we can glean from this record? You're saying there was an undue reliance on a belief that an oral record in front of the issuing officer was insufficient, that there should have been a written record for trustworthiness. What else do you think?
I can't read Judge Ridinger's mind, and
Right.
I'm not going to.
Right, I'm just asking from this record, what else can we derive from this record that would undermine the significant fact?
Judge Ridinger said there were issues of fact about what Officer Stafford did say or did not say to the magistrate, to the state court magistrate. I think what he meant is that because there was no written record, he doesn't know what was said to the magistrate. I think that's what he meant, but it wasn't clear from his oral pronouncement in court exactly what he meant. It wasn't clear to me. And that's why I say to this court that under Winfield versus Bass, where the court does not articulate fully set forth the facts upon which its determination is based, this court must undertake a de novo review to determine what the facts actually show.
How many places in North Carolina these days do arrest warrants issue on the basis of unrecorded, non-written applications? Does that still happen
In my
in
experience,
America today?
in my experience, it happens in every county in North Carolina.
Is that right?
Yeah, I mean,
And do I understand, in Maryland, where I come from, we have judicial officers, not judges, we call them commissioners, who can issue arrest warrants but not search warrants. And is that essentially what's going on in North Carolina? You have some judges who issue arrest warrants, but they're not authorized to issue search warrants?
Well, my understanding, Your Honor, and don't hold me to this, is that a magistrate judge can issue an arrest warrant or a search warrant.
Is it a judge?
It's not a judge, it's a magistrate.
You're saying it's a
different-
local magistrate.
It's a local magistrate, right.
That's what they're called, magistrates.
Local, yeah, right. It's not like a federal magistrate, it's a local.
Do they have to
state
be lawyers?
court. I don't believe they do, Your Honor. I don't believe that's a requirement. Some of them are and some of them aren't, in my experience.
So they don't even have a little cassette on their desk? I mean, our law clerks won't even know what cassettes are.
No.
But you and I remember
Well, Your
a
Honor,
little cassette on the desk to record when an officer comes in, to make some record of what
it looked
of
like
what is said.
It looked like to me when I read the Torchinsky case that was exactly what happened in that case, one of the seminal cases on
But
the
this
arrest
case
warrant
arose
validity.
long after Torchinsky.
Right.
So and you say today they're still doing it.
Well, yes. In fact, the evidence is that this particular magistrate, Magistrate Cornett, if you read the North Carolina law, it doesn't require a written affidavit. It just requires sworn oral testimony. And Magistrate Cornett.
Why couldn't a magistrate just pre-sign all these warrants, and the officer could call them on the phone and fill in? I'm a little flabbergasted, as you can tell. I'm not suggesting for 1 second that this is going to be dispositive of anything, but it just seems to fly in the face of everything the Supreme Court's told us about the role of a judicial officer as the stalwart between the government agent and the citizen. It's frankly a little shocking to me in 2013 to be sitting here contemplating just.
I cited a case, a Fourth Circuit case, in which the holding was the Fourth Amendment says probable cause upon sworn oath or affirmation, and the case that I cited, I can't remember it now right off the top of my head, but it's in the brief, says it does not violate the Constitution to have a sworn oral affirmation before a magistrate judge in order to.
Fourth Circuit also
arrest warrant.
doesn't say a judicial officer shouldn't be paid on the basis of how many warrants he issues. The Supreme Court says that doesn't fly. It can't possibly be consistent with the Fourth Amendment or due process.
The Fourth Amendment allows a sworn oral affirmation before a judge, and that's what the officer did in this case. The evidence is that was the standard practice in that county before that magistrate.
Well, isn't it true that magistrates get dozens of cases brought before them? I mean, every time, at least in Virginia, every time there's a drunk driving citation issued, they have to drag the person in front of a warrant to issue an arrest warrant on him. Isn't that the way it works in North Carolina, too?
Well, in Caldwell County, I don't know how often that magistrate Cornett gets cases, but you're right, Your Honor. It could be a bunch of times. The Fourth Amendment does not require a written affidavit. And
How long after the arrest was the search warrant sought and obtained?
I think it was contemporaneous, but I'm not really sure.
So why couldn't the same application supporting the search warrant be submitted for the arrest warrant?
Well,
I just don't understand it.
It wasn't, Your Honor. But the testimony is that basically the same information that was in the search warrant affidavit was in the oral testimony to the magistrate.
Do the magistrates not like to read?
Your Honor, with all
some people learn from reading and some people learn orally. It's just...
With all due respect, you'll have to address that to the magistrate, Your Honor.
Fair enough.
I don't know.
Speaking of addressing that to the magistrate, under the law of North Carolina, is the magistrate competent to testify to matters that come before him? Can you call him as a witness?
I think you could, Your Honor, but he was not. In this case, he wasn't deposed. I believe he could have been deposed. He wasn't. I think Mr. Elliott and I both know that what he would say is, I don't really remember.
Okay.
But which brings me to the point that if there's an uncontradicted affidavit, which there is in this case, then that establishes what was said to the magistrate. Mr. Elliott conducted no discovery on what was said to the magistrate.
Again, we're just exploring this area. I'm not suggesting anything other than just, I'm curious. How can a defendant in a criminal case who later brings an action for damages contradict an affidavit submitted by the defendant officer as to what the officer told the magistrate when there's no record of what the officer told the magistrate? How could you possibly contradict that?
Well, you'd have to cross-examine the officer, Your Honor, or you'd have to get the magistrate under oath.
It would be the defendant's word. The defendant is brought in front of the magistrate. Isn't that correct? At least I know that's true in Virginia.
Wait a minute. The defendant would not be brought. The criminal defendant is not brought in front of the magistrate.
No, this was an arrest warrant request.
Yeah, right. It was
There's no defendant yet.
There was nobody there but the magistrate and the officer.
That's correct.
No prosecutor, no nothing.
So we revert back to the normal Rule 56 rules, and under Rule 56, an uncontradicted affidavit establishes facts. But we don't even have to get there, Your Honor, with all due respect, because in this case there is so much probable cause. There's an abundance of probable cause established by all kinds of stuff that's recited in the brief at length. Motive and opportunity, abundant. Motive, $4.5 million in life insurance. Evidence of bad marital relations.
By the way, do they still have the option of reinstituting the charge?
Yes. The district attorney, in fact, filed something in the federal district court which informed the court the matter's under investigation. Mr. Anderson is a suspect, and we expect the case to be reindicted. It has not been reindicted, but that's what the district attorney said. That's the state of North Carolina talking. I'm running out of time. I'll just say what this case turns on is the existence of probable cause. The undisputed facts and the facts in the light most favorable to the plaintiff show that there is a mountain of evidence establishing probable cause, which, as this court knows, is not the same as evidence. It doesn't even have to be more probable than not. It just has to be enough to raise a suspicion in the minds, a reasonable suspicion in the minds of the officer. So with that, I'll reserve my remaining time for rebuttal.
Thank you very much, Mr. Morgan. Mr. Elliott?
Thank you, Your Honor. My name is Robert Elliott. I'm from Winston-Salem, North Carolina. We represent the plaintiffs in this action. I want to go to Judge Keenan's question on what got this case off the rail, because I think there is a procedural aspect to this case and there's a substantive aspect to the case. We strongly believe, I can reminisce, and probably few people in the courtroom can remember Paul Harvey, who used to talk about there's this side of the story and here's the other side of the story.
Page 2.
And there was there was clearly another side of this story, as this jury found after a criminal trial, and 11 jurors found this man not guilty. They did not saber rattle until we brought this legal action, and then the Attorney General, when I'm trying to take the deposition of the district attorney, the Attorney General says, oh, he's still under investigation. A month before that, and this is all in the record, we had taken the sheriff's deposition, and the sheriff said we have no active investigation into Mr. Anderson. And that's because there is no evidence. Once the totality of evidence is looked at, the evidence is that Jerry Anderson was innocent of this offense.
Well, but that's the totality of the evidence, and that's not the evidence on which probable cause is based. Probable cause is based on what they knew at the time they went to get the warrant. Isn't that correct?
Well, I do think probable cause is defined as the totality of evidence surrounding the offense.
Well, but you could say he could have investigated this, he could have investigated that, but what the decision is made on is what he knew in his eyes or in his head.
Yes, sir. And he knew about this. He knew about the body of evidence in South Carolina. He knew that there was evidence, there were witnesses.
Now, what he knew was that some ladies found some glasses in a room in the hotel down there. What he knew was that some lady in a old Navy sweatshirt went to a Waffle House. Have you been to a Cracker Barrel restaurant? There are more old Navy sweatshirts than you can shake a stick at.
He knew a lot more than that.
Well, what?
The evidence that was available this time that was in his record because the Duncan Police Department had sent him statements of witnesses. Let's start with the medical examiner. There was scientific evidence that in all probability Emily Anderson died in the several days before her body was discovered.
That it could have been earlier.
It was a remote possibility. And I asked...
Tell me this.
Okay.
If somebody came to you and said, well, would you please tell Judge Gibney that I was installing oil filters on the day my wife just happened to be killed? Would you think that was not, wouldn't you think that was pretty strong evidence that maybe that person was involved in that killing?
Well, in itself, that evidence is one piece of evidence that could be used to show probable cause that he killed his wife.
Well, and that the man and his wife were driving off to a wooded area together. Well, actually, he was in the bulldozer and she was driving separately. Neighbors independently heard 2 shots. She died
In
with
itself.
2 bullet holes in her.
In itself, that evidence, if it had been presented in a fair way, in a neutral way before a magistrate, who is the arbiter of the Fourth Amendment, who's supposed to be the gatekeeper as to what goes forward, and if other evidence in the totality of which he was aware or reasonably could have been aware had been presented,
right,
then we contend there was no probable cause.
But in human experience, an employee doesn't come forward having been told that his paycheck will be cut off if he doesn't provide an alibi for his employer. And the employee comes forward and says, look, I was told I wouldn't be paid unless I came up with this story. I mean, that's pretty powerful, isn't it? That's independent.
That's certainly evidence that the state could use to try to show probable cause. Again, I believe the evidence, and I believe we have presented the facts, the other side that shows that if all of the totality of evidence that had gone to the magistrate or the grand jury, there would have been no probable cause found.
So your theory is that, yes, there was probable cause, but there was sufficient evidence that was so powerful as to undermine the existence of probable cause. And in fact, this being a civil case, I think you agree that for qualified immunity purposes, the defendants don't have to show that they actually had probable cause, right? In the context of qualified immunity under Section 1983, the defendants have to show that they were not unreasonable in believing that they had probable cause, which sort of bespeaks the substantial basis for believing notion from Gates. So they don't even have to show the existence of probable cause, right? So what is your evidence, if you accept all of that, and I ask you to accept all of that for purposes of or for this question, what is your evidence that is so overwhelmingly negative of the existence of probable cause that any reasonable officer could not possibly have believed that he or she had probable cause, in light of what Judge Gibney and Judge Keenan have gotten you to agree? Yeah, they could. You've said it about 5 or 6 times already. Yeah, they could use that. Yes, they could use that. Yes, they could use that. And that's clear. So, what undermines all of that? What in this record so undermines the existence of probable cause that not only is there no probable cause, but no reasonable officer could possibly have thought there was probable cause?
And let me be clear about what I've agreed to. I've agreed that there's going to be evidence from both sides presented to a magistrate or to the grand jury, and the magistrate, or the DA for that matter, and the magistrate or the grand jury then looks at that evidence and determines whether there's probable cause. And the violations...
I'm sorry, I have to disagree with you, Mr. Elliott. There are very few jurisdictions in this country where the defendant gets to present evidence before a grand jury. The probable cause analysis is,
yes, sir,
is, as a matter of law, ex parte and one-sided.
And I didn't mean anything to the contrary.
Okay.
I'm saying the officer at that point presents the evidence to the grand jury or to the magistrate. The officer is under a constitutional obligation to present all of the evidence of which he is aware that's material to the determination.
What do you cite for that proposition?
I cite the Miller versus Prince George County. I cite the Savigny case. I cite even these recent cases that the court has decided where they say an officer cannot go in and lie, an officer cannot fabricate. Those are constitutional violations.
Well, that's interesting. What did he say that was false?
Sir?
What did the officer say to the magistrate that was false?
Well, for one thing, he completely left out this whole body of evidence that showed my client was innocent.
No, you're talking about then the difference between commission and omission. You're saying what was omitted. What was he lying about? What sin of commission did he commit?
Most of it was commission, but the commission was so strong that it amounts to, in our opinion, it amounts to intentional deception. He brought forward the cadaver dog evidence, and he talked about how he had highly trained dog handlers out there reviewing that ground to see if there was bodily fluids. He never, and that one of the dogs alerted. He never mentions that another dog did not alert. He never mentions that the ground was tested and it was found negative.
Why does he have to? There's nothing that says he has to present the whole body of evidence.
Well, we contend he does, and we contend that the cases of this court indicate that he does have to present all available material information. He doesn't have to chase down every lead. I'm not saying that. But when you have evidence that places in doubt that evidence he's relying on, he has an obligation to present that. Otherwise, you don't have a neutral arbiter who's trying to make an independent decision, and the guarantees of the Fourth Amendment are nothing.
Do you contend that there was a time at which Captain Stafford had an obligation to go to the prosecutor and say, you need to drop this case? Is that part of your claim here?
No, sir. No, sir. I don't say that at all. And I think
okay. I'm just making sure.
All I'm saying is that the officer has to present all the information. And then if others are going to make the decision, particularly if they're going to break causation, those others have to have the information before the officer's let off the hook.
Part of your argument is that he didn't follow enough leads. Isn't that right?
That he
didn't follow leads that he should have followed.
That's a small part of our argument. That's a small part of the argument. I mean, the evidence on which we have relied to show that there was no probable cause was out there. He knew about it. He avoided it.
Well, the paint chip issue came up much later.
It did.
Didn't it? Okay. And so you're saying the dog handler issue was known to the officer. What else?
Okay. I'd like to take you through some of the evidence that was totally omitted. That no reasonable police officer, and we have an expert who testified in this case, no reasonable police officer would have not investigated evidence of which he knew of this nature. The first is the most important because it's scientific evidence, and that's the medical examiner. And yes, in the end, they were able to get her to say that there was a remote possibility it could have been 10 days. But the probability of her opinion, based on her science, based on 2,500 to 3,000 autopsies, was that Emily Anderson died within 2 to 4 days prior to the discovery, prior to her autopsy. And that's undisputed. It's also undisputed that when the officer, Stafford, found that out, he tried to talk her out of it. He resisted it. He went to her supervisor and found that her supervisor agreed with her. Now, what he didn't do was show her objective evidence that would have even made that opinion more powerful. And that was the evidence of photographs that are in the record where you see her hands are in rigor. And if there's an objective factor on the timing of death in this record, it's rigor mortis. Again, the experts, every expert has said that rigor mortis passes within 24 to 48 hours. On the Sunday afternoon of January 8th, there was no rigor mortis when she did the autopsy. But there's evidence of which she was not made aware that the day before there was rigor mortis. And that would have solidified her opinion, along with the other factors she goes through in her affidavit, that there was a scientific reason that supported the fact that Emily was alive in South Carolina. Now, that was corroborated by these South Carolina witnesses. And there were 5 witnesses. With all due respect, Your Honor, it wasn't just witnesses who saw an Old Navy shirt. We had a witness from the Waffle House who had come within the distance between me and you and had seen a man with a crew cut in the doorway of this truck.
Now, I'm sorry to cut you off, but how does any of that undermine neighbors hearing shots, they go off in the woods, the false exculpatory kind of testimony from the farm hands? How does any of that so undermine what the captain knew and presumably told the magistrate about, so as to convince us that there's a reasonable probability that the magistrate would not have issued that warrant? Maybe the magistrate would have scratched his head and said, gee, this is an odd case. Gee, this is odd autopsy evidence. Gee, I've never seen rigor so late after death.
Yes, sir.
But why wouldn't the magistrate issue the warrant?
Because that was clearly more reliable evidence that she had been alive in South Carolina and there was a scientific basis to it, rather than circumstantial evidence of gunshots in an area where gunshots were heard all the time, where the employees had supposedly seen a truck and a heavy equipment going down the road somewhere about 1.5 miles from where they say it took place, the murder took place. They had not come forward in 10 days. I understand that a lot of that is impeachment evidence at criminal trial, and it was used. And this employee didn't come forward in a criminal trial to say he had been threatened in the least. But I understand at this point in time, that was evidence on which this magistrate, if that was the only evidence, could have said there's probable cause. But we contend that the evidence in South Carolina, and particularly the medical examiner's evidence, negated that probable cause from that circumstantial evidence. It was strong enough that if it had been presented, it negated probable cause. And the cases of this court say that if there's exculpatory information that's available to the officer and he excludes it, he doesn't use it, or he doesn't present it to the arbiter, then it negates, then it's a constitutional violation.
If we disagree with you on the issue of probable cause, do you have any state law claims that survive?
Well, the malicious prosecution claim, just as in the Evans case, I think would survive. I think there are different elements to the state constitutional claim. I mean, the state malicious prosecution claim.
You're saying that the presence of probable cause does not negate a malicious prosecution case in North Carolina?
Well, under my understanding under North Carolina law, under malicious prosecution, that the termination of proceedings in favor of the plaintiff indicates a lack of probable cause. And that's one of the elements under the North Carolina tort. There's a procedural aspect to this case that I think is very important.
So is that the only state law claim that survives malicious
There are several other state law claims, Your Honor.
Right, but I don't see any that would appear to survive.
That is the primary one.
Okay.
Why wouldn't immunity apply to that claim, the malicious prosecution claim under state law?
Well, it could. Of course, that issue is not here at this point, but if
I'm not sure I follow that. It's not here against the
It was not part of
against
the
the officers?
Sir?
I'm sorry.
I
I
think
thought the officers were appealing,
in
taking an interlocutory appeal on the basis of qualified immunity under federal law as well as official immunity or governmental immunity under the state law claim.
Okay. Public official immunity should not apply because there was malicious acts. There were deliberate acts by the officers. And public official immunity
Judge
wouldn't apply.
Keenan, I think, is asking if there's probable cause, doesn't that negative the possibility of malicious acts under the state law claim? How could a malicious prosecution claim survive if there's probable cause?
But there is no probable cause
Okay.
with a termination in favor of the plaintiff.
Assuming there's probable cause, does anything survive of the state or federal claims if there's probable cause?
Not that I can speak to at this point, Your Honor.
Okay.
Again,
so your answer to Judge Keenan was the malicious prosecution claim would survive if there's an absence of probable cause.
and there is.
Okay.
Under North Carolina law, there is. That's what I'm saying. Looked at under 1983 as a different test. Under North Carolina law, the termination in favor of the plaintiff is evidence of lack of probable cause.
And is a hung jury a termination in
Yes, sir.
favor under state
And a
law?
dismissal, and a later dismissal. There was other evidence. I mean, the Quality Inn employees, the two employees who were on the second floor balcony, had a clear view of the truck and saw people getting in and out. I want to emphasize that no keys were found of the truck when the body was found. So somebody in South Carolina, according to these witnesses, whether or not they could identify Emily or not is another issue, but somebody was getting in and out of that truck, which indicates that she could have been alive in South Carolina, along with the medical examiner's evidence, and Mr. Bomar, who waved to the man. Mr. Stafford, in the deposition, when he was asked why he didn't, if he didn't go talk to these witnesses because he didn't believe them, he said he did believe them. That he didn't. He believed that they saw what they saw, and he didn't make any assessment that they weren't credible. And that's why we're not talking about just chasing down leads of other people who might have called in. These were solid witnesses who saw people getting in and out of the truck. Now, if that had gone to the magistrate, along with the medical examiner's opinion, along with the photographs of rigor mortis, we contend the magistrate would not have found probable cause and the grand jury would not have. The fact is that what's not disputed in this case in any way is that this police officer formed a belief as to my client's guilt and took it on himself to present in an adversarial way the evidence to the magistrate and to the grand jury and totally excluded that evidence.
Do you have a unified theory as to who killed her?
No, sir. Somebody in South Carolina.
Somebody in South Carolina. So you think she drove to South Carolina on her own?
I don't have that theory, Your Honor. I mean, that evidence could have been there. And I totally believe my client's innocent. I don't know whether you're asking that, but I totally believe it.
I never ask a lawyer that.
All right.
That would be.
But I don't mind telling you, it's a civil case.
It would be objectionable on its face.
But we don't have a theory because that evidence got cold. There was no effort to chase down evidence in South Carolina and try to figure out what happened. I just want to emphasize in my last 20 seconds that there is a procedural aspect to this case that Judge Reidinger talked about a great deal. Judge Reidinger reviewed the volumes of the joint appendix that you have, or all those documents, and he determined that there were these issues of fact that needed to be determined by the jury. And Judge Davis, in your dissent, in your concurring opinion in the Henry case, in the en banc decision, you make it clear the jury is the fact finder. The jury is supposed to make decisions on facts and inferences from facts. And we contend that there are facts here that, if believed by a jury, would establish that there were constitutional violations of my client's Fourth Amendment rights, that, as Judge Wynn said in his dissent in the Durham versus Horner case, and You might have questions whether he's an innocent man. We're ready to put that to the jury in a civil case. If a man is innocent and his rights have been violated, where is he to turn? And we contend that he turns to the United States District Court and to a jury to recover the unsurmountable, the incredible losses that he suffered. Thank you.
Thank you very much, Mr. Elliott. Mr. Morgan, you have some time remaining.
First of all, under North Carolina law, the existence of probable cause would defeat a claim for malicious prosecution. That's clear under the case law. In this case, probable cause existed at the time that Mr. Anderson was arrested. It existed at the time the arrest warrant was sought, and it still exists today. Mr. Elliott was asked in essence, you asked him what evidence was fabricated, what lie was told. He cannot articulate it because there is no evidence of that. Even though Judge Ridinger said there's an issue of fact as to whether evidence was fabricated, Judge Ridinger did not tell us what that was, and Mr. Elliott hasn't told us what it was, unless, as in his summary judgment argument before the court, it was the videotape of the second set of searches by the cadaver dog of Mr. McNeil, and that does not defeat probable cause. It's just one small part of this mountain of evidence that establishes probable cause. In spite of what Mr. Elliott says, the medical examiner has been consistent from the first day until the last time we talked to her. She said time of death is consistent with 2 to 4 days, but I cannot rule out a much longer time, including 10 days. When you combine that with all the other evidence, you've got probable cause. The later evidence that Mr. Elliott has come up with, which is he showed the medical examiner some photographs, and she said, well, it looks like there was rigor mortis there. But what he leaves out is that the plaintiff's other expert, Dr. Marks, looked at the same photograph and said, I can see there's no rigor mortis there. So you've got two experts saying, one says rigor mortis, one says no rigor mortis. Officer Stafford testified that he didn't think there was rigor mortis. And when they got the body, they uncrossed the legs and uncrossed the arms, which would indicate to a layman there was no rigor mortis. So
Is there any evidence in the record regarding weather conditions, climate conditions during the relevant period?
I don't remember, Your Honor. I know it was January. It was Christmas in January, so it was probably cooler. But I think, I don't remember. There may be something in there. I just don't remember right now. I think it is relevant when you're considering qualified immunity what actually happened in this case. Officer Stafford accumulated all of these facts that are set out at length in the brief, and he said, I think there's probable cause. He went to a magistrate. The case is U.S. versus Clyburn, where the Fourth Circuit says unsworn testimony can be used to establish probable cause.
But you don't rely on any presumption here, do you?
There is a presumption of reasonableness when an officer arrests pursuant to a warrant. There is a.
But you don't rely on that presumption in this case, do you, in the absence of a written application?
Yes, I don't have to, Your Honor, but I think it's there. I do think the presumption's there. And what Torchinsky says, if I recall correctly, is that there's a presumption of reasonableness which can be rebutted by this. If you can show that no reasonable officer would have concluded there was probable cause, then you can rebut the presumption.
How can there be a presumption in the absence of a writing or other recordation of what the magistrate acted on?
I believe that the case of the Torchinsky case, which is the case where the phrase presumption of reasonableness comes from, I think if you read that case, it becomes fairly clear that there was no written affidavit before the magistrate in that case.
Well, the case uses the term application.
But it also says that you had to rely on the deposition of the officer in order to establish.
Well, does it say you have to, or you're entitled?
That's how I read it. I don't think it says specifically if there's a written application or not. Application can be written or oral. But we don't need to get there, Your Honor. In this case, the magistrate, the grand jury, the district attorney all concluded there was probable cause. In addition to that, there was a 2-month-long trial. The state court judge listened to all the evidence, and it's all the evidence that the plaintiff is relying on here. It's all of that evidence. He heard the evidence. He listened to the arguments of the very capable criminal defense attorneys that Jerry Anderson
We don't know
employed.
whether the evidence they produced at trial is the same evidence they produced before the magistrate. We don't know what was produced to the
That's
magistrate.
correct, Your Honor. Well, we do know
So
because
the
we have,
fact that the judge didn't strike the evidence really doesn't tell us very much.
we have the affidavit of Officer Stafford, so we know generally what was told to the magistrate. But what I'm getting at, Your Honor, is that the judge heard all of the evidence at the criminal trial, which included the evidence of the prosecution and the evidence of the criminal defendant and the arguments of the criminal defendants. And the judge concluded that not only was there probable cause to go forward with the case, there was enough evidence to convict Jerry Anderson of
How
murder.
long was the jury out?
I don't know.
Aren't you curious about those kinds of questions?
Well, Your Honor, I am. There's a whole lot of stuff I was trying to prepare for. I didn't go back and look at that.
Fair enough.
I think they were out for a while because it ended up being 11-1 in favor of conviction. One juror was not convinced. One juror was convinced of his.
I thought it was the other way around.
I said it backwards.
Yeah.
It was 11-1 in favor of
Acquittal.
acquittal. I'm sorry. Yes, I heard Mr. Elliott mumbling behind me. Yeah, I had it backwards. I did not mean to misrepresent that. But I do think it's significant, and I cite cases in the brief that say.
By the way, under North Carolina law, I'm sorry to interrupt, is there a motion for judgment of acquittal after a mistrial allowed under North Carolina practice? And do you know if it...
I don't know. I don't know if it was allowed, and I don't know if it was made.
Well, we certainly know it was denied if it's allowed and if it was made.
He wasn't acquitted. There was a hung jury. In this case, the fact that all of these judicial officers concluded there was probable cause suggests, and I think means, that you would have to say that all of these officers, including the state court judge, were completely unreasonable, were incompetent, in fact, in order to conclude that the officers were not entitled to qualified immunity. Thank you for your attention.
Thank you very much, Mr. Moore. We'll come down and greet counsel and proceed immediately to our last case.